major breaking news. The Donald Trump Department of Justice and the Solicitor General of the United States has just effectively conceded that 18, 19, and 20-year-old Americans are entitled to full-blown Second Amendment rights under the Second Amendment. That's right. The Solicitor General has chosen not to seek cert in the Reese case out of the U.S. Court of Appeals for the Fifth Circuit. Let's break down this huge breaking news in favor of the Second Amendment when we come right back. Hey folks, I'm Mark Smith, host of the Four Box of Don, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, this is huge, precedent-setting news. Extraordinary news. And as you know, if I say it's extraordinary, it is, because I know. The United States Court of Appeals for the Fifth Circuit, as you may recall, out of Texas, Louisiana, and Mississippi, had found earlier this year that 18, 19, and 20-year-olds were entitled to full-blown Second Amendment rights. And that federal gun control law that said that 18, 19, and 20-year-olds cannot acquire handguns from FFL's federal firearms licensees, that law was unconstitutional. A major win for the Second Amendment, a major win for the Bruin methodology, the originalist methodology of text first, and the historical tradition of firearms regulation, if any, second. This is a major win. This declared that gun control law, a federal gun control law, was facially unconstitutional. Not just as applied to the plaintiffs in that case, but facially unconstitutional under the Second Amendment. Well, the breaking news is, folks, that despite a U.S. Court of Appeals, a lower court, finding that a federal gun control law is unconstitutional, guess what? The Donald Trump United States Department of Justice and John Sauer, the Solicitor General of the United States, who represents the United States government and Donald Trump in front of the Supreme Court, they have chosen not to seek cert and overturn that decision. They have decided not to seek cert by going to the U.S. Supreme Court, asking the Supreme Court to overturn that decision by the Fifth Circuit. By virtue of not seeking cert, the U.S. Department of Justice has, for all intents and purposes, conceded the point that the Second Amendment does indeed protect the full-blown right to keep and bear arms of 18, 19, and 20-year-olds. This is extraordinary. There's no other word for it, folks. Okay? It's extraordinary. From my recollection as a member of the United States Supreme Court Bar and as a longtime litigator in all the courts in America, I cannot recall another instance where a federal law was declared unconstitutional by a lower court, and the Solicitor General of the United States decided not to seek cert to vindicate that statute. We do have an instance in the Windsor case, which we talked about before, where the Solicitor General for Barack Obama asked the Supreme Court to grant cert in a case involving the Defense of Marriage Act, but only for the purposes of flipping sides. Here in the Reese case, out of the Fifth Circuit, the Department of Justice has simply chosen not to seek cert, which means that the U.S. Court of Appeals for the Fifth Circuit's precedent that says that 18 through 20-year-olds have full-blown Second Amendment rights and that the federal gun control law is unconstitutional, that is now binding precedent. It's not going to get reversed. The only person or the only group that can overturn that is the U.S. Supreme Court. And the only way the U.S. Supreme Court can overturn that pro-Second Amendment ruling out of the Fifth Circuit in the Reese case is if somebody was standing requests the Supreme Court to do so. And because this deals with a federal gun control law defended by the U.S. Department of Justice and the Solicitor General's office, which is part of the Department of Justice, because the SG's office has chosen not to seek cert, that Reese precedent will stand. Now, in addition to this being extraordinary, because in my entire memory, I can't think of this ever occurring in modern American life, where the Solicitor General allows a lower court decision to declare a federal statute to be unconstitutional on its face. The fact they didn't seek cert is extraordinary. It's also extraordinary in the sense of how pro-Second Amendment it really is. That a major win for the right to keep and bear arms is just left on the books. And by the way, remember how I told you before the election and after the election? I said that the most pro-Second Amendment administration, the most pro-Second Amendment president ever in American life was Donald J. Trump. Some of you thought I was engaged in hyperbole. You thought I was exaggerating. And I told you, no, I'm not. I'm telling you point blank, this is the right answer. Because there's other presidents that have been good on guns. But the difference is those presidents good on guns back in yesteryear, they didn't have a multi-billion-dollar anti-gun movement and lobby attacking them every day, all the time, which is what President Trump does. And just to put this in perspective, I can assure you this. If any other Republican president were in office, and I'm talking about George W. Bush, George H.W. Bush, Ronald Reagan, John McCain, Mitt Romney, any of these people, their Solicitor General 100% would have sought cert and would have sought to vindicate and uphold that federal gun control law, because they would have done so on the grounds that they're law and order conservatives, they're law and order Republicans. But President Trump and his Department of Justice, being the most pro-Second Amendment president in American history, certainly modern American history, his Department of Justice did not do that. They let a hugely pro-Second Amendment precedent stand on the books, and they did not rush to the Supreme Court to see if they could overturn it. And I will tell you this. If the Solicitor General of the United States asked the Supreme Court to hear a case where a federal statute of any sort has been declared unconstitutional on its face, and the Solicitor General asked the Supreme Court to hear that case and overturn it, 99.9% of the times, if not 100% of the time, the U.S. Supreme Court will grant cert and hear that case. Now, they may agree or disagree with the U.S. government, but 99.9% of the time, they're going to hear that case. So the fact that the Solicitor General John Sauer, who I told you was very important to the Second Amendment movement, but we had to get him confirmed, just like we had to get Harmeet Dillon confirmed. You had to get these people confirmed for the full-blown and the full effect of their pro-Second Amendment positions could be felt by the American community. That had to happen. And once that's happened, you can see what's going on. There's gangbusters is what's happening all across America when it comes to our Second Amendment rights. We also, of course, have to recognize, in addition to this being an extraordinary decision, and this being extraordinarily pro-Second Amendment, to allow a federal gun control statute to fall by the wayside in major states, like down there in the Fifth Circuit. You also have to agree that Donald Trump gets great credit. Again, none of this happens without President Trump picking the right people to support the Second Amendment. Donald Trump can't be everywhere at all times. He has to pick good people. And I think it's fair to say that the biggest criticism of President Trump in his first term was that some of the people he picked to work in the White House, to work in the Department of Justice, were not up to snuff. They weren't as strong. They weren't as courageous. They weren't as committed to the MAGA movement as we see now. And personnel is policy. If you get the right people in there, you're going to get the right policies. And that's what we're seeing. Now, I want to rebut a comment that I'm sure I'm going to hear. And it's a legitimate comment and question. And that is this. Somebody was going to say in the comments below for sure something like, hey, Mark, wouldn't it have been better if the Solicitor General of the United States for Donald Trump had sought cert and pulled a Windsor like you've talked about before, which is they would have sought cert, asked the Supreme Court to hear the case, and then argued to the U.S. Supreme Court that this federal gun control statute was unconstitutional. Well, here's the story, folks. If we were 100% certain that the U.S. Supreme Court would have ruled for the Second Amendment and affirmed the Fifth Circuit, I would agree with you. But the fact is that Judge William Pryor has thrown the Second Amendment under the bus with a terribly reasoned, in my opinion, view. In that case down there in the 11th Circuit, in that split en banc decision, where he ruled that 18, 19, and 20-year-olds can be deprived Second Amendment rights, which I think was totally wrong for 6 ways to Sunday. Nevertheless, the fact that a so-called conservative William Pryor did that and issued that ruling proves that there is not a 100% guarantee that the Second Amendment movement would have won the Reese case before the U.S. Supreme Court. I think we likely would have won. I think the arguments is definitely in our favor, because how can you argue that 18, 19, and 20-year-olds have no full-blown Second Amendment rights under the Second Amendment, given the fact the Militia Act of 1792 said that 18, 19, and 20-year-olds were part of the militia that had an obligation to bring their own privately owned firearms with them to militia musters. And even if you assume the biggest argument that the anti-gunners have on 18, 19, and 20-year-olds as an argument, that you can derive a principle that minors can be disarmed. But again, if you think about it, today in the year of our Lord 2025, what's a minor? Well, 18, 19, and 20-year-olds are no longer minors. They're full-blown adults. They can get married. They can change their sex, apparently. They can get tattoos. They can enter into contracts. They can do all sorts of things, right? They can buy homes. The point being that even if you want to argue that in 1791, the principle to be derived by historical precedent is that minors can be deprived of the right to keep and bear arms, let us assume that is the principle derived from history. When you apply that principle to today's world, 18, 19, and 20-year-olds are no longer minors, which means the principle, to the extent you want to argue there is a principle that says minors can be deprived of their Second Amendment rights, that would only allow you to disarm, let's say, people under the age of 18. Because once you hit 18, you're no longer a minor. You can be thrown in prison, the death penalty can apply to you, and so on and so on. So again, whether you just want to say it's simply historically false that 18, 19-year-olds don't have full-blown Second Amendment rights because of the presence of the Militia Act of 1792, or you even want to assume, for the sake of argument, the anti-gunner theory that minors could be deprived of the right to keep and bear arms, even if you assume that principle is true, either way, the Second Amendment community should win. But again, one never knows exactly what happens at the U.S. Supreme Court level, even though it's obvious we should win. It's not guaranteed, as illustrated by the fact that Judge William Pryor, who is a Republican appointee and a relatively conservative judge down there on the 11th Circuit Court of Appeals out of Florida, among other things, he screwed this up 6 ways to Sunday. Okay? It's just the reality of it. Embarrassing. Embarrassing for him, as far as I'm concerned. But he did it. He had his reasons. He screwed this up. And shame on him. But nevertheless, if he can screw this up, no guarantees that some other justice on the Supreme Court might screw it up too. There are no guarantees in this life except death and taxes, as they say. The only other point I want to make that might come up in the comments is, how does this differ from the Brian Range case arising from the en banc decision in the U.S. Court of Appeals for the Third Circuit that said that nonviolent felons could not always be disarmed automatically, and that Brian Range, who was a nonviolent felon for a misdemeanor conviction decades ago, he could get his gun rights back. And the Solicitor General of the United States chose not to seek cert in Range either. Well, the difference is, and why Reese is a much bigger deal than Range, is that the Third Circuit decision in the Range case was as applied to Brian Range. So while that Third Circuit case does have precedential effect, it can be used favorably to advance or protect or restore our right to keep arms. The Reese case is a much bigger deal because it's a facial challenge to that federal statute, that federal gun control law, and it was deemed unconstitutional facially as applied in all instances. That was the decision in Reese, and that's why not seeking cert in Reese is a much, much bigger deal than even the big deal of the Solicitor General and the Trump administration not seeking cert in range. So as you think about this, Reese not seeking cert, bigger deal than not seeking cert in range for those reasons. One was as applied, one is facial, and they didn't seek cert in either, allowing these victories for the Second Amendment, these precedents, these bricks in the wall around our rights to stand and not be thwarted potentially by an adverse ruling in the U.S. Supreme Court. So kudos to the United States Department of Justice under President Donald Trump, under Attorney General Pam Bondi, with the efforts of John Sauer, the Solicitor General, and Harmeet Dillon, and all those other great individuals whose names appear on that powerful brief in the U.S. Court of Appeals for the Seventh Circuit in Barnett. There's a whole list of people working hard on the Second Amendment in the administration, apparently based on all the outside evidence. And I'm glad that they are doing so. America will be better for their efforts. The Constitution will be better for their efforts. And certainly our right to keep and bear arms will be better for their efforts. And they're just getting started. A lot more time between now and the end of Donald Trump's second term. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4Boxes Diner. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.